I'm going to talk a little bit about data protection law, which is something, I don't know if any of you consider yourselves experts on the subject or come into contact with it day to day. It's a bit of a specialist area, but it's been getting a lot of press recently, and I guess it's going up corporate agendas in terms of being something you can get hit with very big fines for if you get it wrong. So I'm going to talk about some of the basic things about data protection or data privacy law, and also share some of the experiences that I've had since, well, I've been doing data protection law for a long time, as you'll see, but it's quite interesting that when we work with people at Thornton, people find the same areas very, very difficult. Nearly every organisation we work with finds the same problem areas, the same, rub points. And I'll talk a little bit about what those are in a minute. Yeah, I got into data protection actually working in the building which is directly opposite us across the river, which is called Alberton House, which used to be a tax building, but then various floors were sold off and it was a classified ads paper. So I worked there for quite a few years, ended up getting into data protection through that because, as you can imagine, when people sell second-hand goods, there are all sorts of issues about selling stolen goods, about selling goods that shouldn't be advertised for sale, firearms and hand grenades and all sorts of things we had people trying to sell. It was quite incredible. This was before the internet really took off, so classified ad papers were quite important in terms of buying and selling and making contacts and personal ads and all that kind of stuff. So I got into data protection through doing that. Then I went to work for the regulator, the ICO, for over 20 years, so I'm a bit of a veteran of the data protection area, and certainly when I started doing data protection it was a really geeky specialist thing and no one really heard of it. I think it's very different these days in terms of it becoming a lot more mainstream. So I was involved in enforcement work, started off doing complaints handling, policy and guidance, and was the kind of principal author and worked with a team of people doing most of the big pieces of ICO guidance that came out under the old legislation, so stuff on data sharing, anonymisation, privacy notices, data protection in the workplace, and personal information online, when we talked about online identifiers and things that seemed very science fiction at the time but are quite normal now in terms of how regulatory standards for doing things on the internet have evolved. So I'm very much a sort of policy guidance background. In later years, I spent a lot of time in Brussels for like 4 or 5 years, advising the UK government on the GDPR when it was being drafted, because there's not a lot of technical expertise within the government itself, so they used to ask for people from the regulator to help them with some of the more sort of tricky bits about definitions and scope and things like that. So that's what I spent a lot of time doing the last 4 or 5 years in Brussels, sat behind UK government delegation, giving them bits of paper saying, no, don't do it that way, that's going to be really, really bad. And GDPR is a bit of a mess, but it could certainly have been worse. So when you're sort of struggling with it, just bear that in mind. I joined Thornton a couple of years ago, coming up for 2 years now, to head the data privacy practice. So I'm kind of doing what I used to do at the ICO really in terms of helping organisations to comply. So that's my background. The GDPR is a complicated piece of law. It's got its own parallel language. It's not terribly well drafted. It's very, very complicated. But it boils down to some quite simple things, really. And I think if you can cut through some of the technical detail and focus on those simple things, life gets a lot easier. Things like transparency and the basic principle that when an organisation collects personal information about you, you should know what they're going to do with it. In reality, few people read privacy notices, but it's a legal requirement that you have them, and you should try and make them as useful and clear and intelligible as possible. And a lot of the work we do is with organisations trying to sort out their privacy notices, which are often drafted by lawyers, perhaps inevitably a bit technical, but we do a lot of work trying to make them much more plain English and much more relevant to the people who are using their services. There's a whole lot of rules around information standards, accuracy, relevance, keeping information up to date. As you'll see in a minute, those are all areas that organisations find difficult. There's a set of individual rights we all have, The most obvious one is subject access. That's when you ask for a copy of your information. Nearly everybody we've worked with say they're getting more subject access requests these days because the £10 fee that used to be in place is now gone, so it's free. And you may think that £10 isn't very much, but if you speak to anybody who deals with big volumes of complaints, like say a retail bank, they will say that we get X thousand complaints through the door. If we go back to them and say, yeah, okay, but can you send us £10? A lot of people go away. So that filter's gone. So generally, organisations are dealing with higher volumes of complaints and dealing with complaints for the first time. I mean, there are organisations we've dealt with who have been, going for, in some cases, hundreds of years, who've never received a request until recently. So it's becoming more of a public issue. And I think generally if a customer or somebody you deal with or an employee doesn't like your company very much, or they're in some sort of dispute, making a subject access request becomes something that they will do. So you can expect to get increasing volumes of those. There's also stuff in the law now about accountability, which is a very kind of continental concept whereby it's not just about complying, it's about having the paperwork to show how you comply. There are similar things in other bits of financial services legislation, but doing things like having a record of processing activity, knowing what information assets you have, what they are, which people they're about, where they come from, who you share them with. The GDPR is a lot stronger than the old law in terms of those kind of paperwork things that you have to have in place, in which the regulator can ask to see if they've got some sort of issue with you or they receive a complaint about you. International transfer rules, and there's all sorts of issues around the UK leaving the EU and the implications of that at the moment. But the basic system is that if you've got personal information that you collect and that you're corporately responsible for, then wherever it's stored geographically, whoever you share it with, you have to have the governance in place to ensure that it remains properly protected, and that's what that's about. So, and then of course information security rules, and most of the stories you'll see in the press recently about BA and Marriott and the ICO, which is just down the road in Winslow, saying they're going to fine people hundreds of millions of pounds. So far they've been around information security breaches, but no doubt as things progress, other breaches of the legislation will also get some attention. So what's new? Not very much in a way, because the GDPR is based on those simple basic rules which I just explained to you. There are some significant differences. Online identifiers, things like IP addresses, device identifiers, the law has made it much clearer that those are within scope. This was something which both regulators, lawyers, the courts and the industry had largely accepted anyway. But certainly when I started doing, working with some of the technology companies when I was at the ICO, and we used to argue about, well, they say, well, we're just tracking somebody's phone. So no, you're not, you're tracking them. You don't send an advert to a phone, you send an advert to a person who's got the phone. And we used to have these kind of silly arguments about scope. Eventually everybody kind of accepted that the way people are identified has changed, it's expanded, there are different ways of identifying people. And the GDPR makes that clear, which is good. There are some new rights, data portability, for example, which is the ability to request a copy of your personal information in a machine-readable format, so you can transfer it easily from one organisation to another. There are similar things in, for example, rules to do with utility companies. It's been around for a while in some forms, but that's a new right. So far, I don't think many people are using those rights. I think it's mainly subject access, but there are some new rights. As I said, subject access requests are now free, which of course has implications. It's more prescriptive, it's more detailed. A lot of things that were good practice guidance, things like the stuff that the ICO put out in its codes of practice, found their way into the law. So what used to be good practice became statutory requirement, and that's one of the sort of themes underlying the GDPR. It's certainly a lot more heavy in terms of you having to be able to demonstrate that we've got all the right policies and procedures in place. And when we work with people at GT, that's what, we spend a lot of time doing that. New rules around international data protection authority cooperation, which again, we're not quite sure what the future is going to bring, but that could lead to a ratcheting up of data protection rules across Europe. And I remember years ago, when Google was launching Street View, there was a big fight between the European data protection agencies, and essentially the ICO, the Brits and the Irish and various other people weren't very bothered. We thought it was just pictures of houses, pictures of roads, who cares? Other countries thought it was really, really terrible, very, very intrusive. Apparently in France it's illegal to photograph a domestic property without permission. Some parts of Germany outlawed it, others didn't. The Hungarians didn't like it at all. And under the new system, if it came to a vote, you'd probably find that Street View would have been banned across Europe, whereas what happened was it was launched in most countries in Europe, and it was launched in a moderated, an altered form with greater safeguards in other places in Europe. And people use Street View with apparently very little sort of privacy effect. So it'd be interesting to see what happens once the Europeans get going on their consistency mechanism, and there could be much more problematic decisions coming out in terms of the standards you're expected to reach. Also, the issue about the penalties has grabbed the headlines, and I'm not surprised. The old maximum fine in the UK used to be £500,000. It's now up to 4% of annual global turnover. We saw in the press recently about the ICO intending to issue a notice that they're going to intend to fine BA £183 million. So, I mean, back in the day when we used to fine, when I was at the ICO, we used to fine people a few tens of thousands of pounds. They often used to pay up and kind of keep the publicity down and roll over, and that would be it. You're not going to just sort of sign off £183 million, are you? So you can expect to see more action in the courts, more appeals, and BA have said they're going to appeal. So, which is actually good because it should clarify the law, and it should tell us more about how the ICO works out the amount of fine it's going to issue, because at the moment I think it's something of a mystery, so that will become hopefully more transparent. These are the problem areas, and since I joined GT, we've worked with maybe 100 different organisations. There's about 100, over 100 data protection type jobs in the last couple of years. And wherever we go, whether it's a financial services company, a retailer, a technology company, a property management company, whoever it is, they nearly all have the same sorts of problems. And it's these ones. There's a requirement under the GDPR to keep a record of processing activity. That's essentially an information asset register. It's not entirely clear what the difference between the two is, if any. But what it means is that you need to be able to demonstrate, if asked, that you know what personal information assets you've got, which systems are held on, what sorts of people they're about. Is it employees? Is it customers? Is it other people? Where does the information come from? Who do you share it with? What kind of security is surrounding it? So this is new, and organisations are finding it very, very difficult to do. I think the only organisations I've come across who can say hand on heart that they're 99% there in terms of having a complete record are companies that have only been in existence for a couple of years maybe. But once you start dealing with legacy systems and companies that have even been around just a decade, stuff accumulates. You end up with non-official filing systems and people keeping things on their own drive, people keeping things in email attachments rather than official systems, and that's when you get problems dealing with subject access requests, for example. But people are finding that very, very difficult. Information asset registers it's the same thing really, but that's an area that people find very, very difficult to say we actually know what all the information we've got is. Everybody seems to find that difficult. Kind of connected to that, the GDPR is about necessity, not keeping information if it's not necessary to do so. So rules around retention and deletion are always a problem. I don't think we've worked with anybody, again, apart from very, very new organisations who can say we need all the information we've got, who can say that everything is being kept according to an effective retention deletion schedule. Everybody finds that difficult. It's a basic records management thing, but it's often one of those areas that people think, well, that's just too difficult. We'll, do that another day. And people invariably find the retention deletion thing difficult. Also, like I just said, the GDPR is very strong about networked information and information sharing, and getting a handle on who all your third-party suppliers are what personal information they have access to and checking your governance is in place to make sure that they have appropriate security in place is a nightmare. Again, very, very few organisations we've worked with can say they know who all their third-party suppliers are. You're supposed to have GDPR compliant contracts in place. Most organisations haven't got that. They're sending out amended contracts in repapering exercises, not getting replies back. It's really, really difficult, and it's one of those, and you know, a lot of fintech companies, for example, we work with various organisations who don't really do anything in-house. They're just a sort of nexus where a whole lot of third-party services come together. So this is really, really critical for those organisations, and that's clearly becoming the rule rather than the exception. Marketing rules are also difficult. Marketing rules are about to change. They're governed by the Privacy and Electronic Communications regulations, and you get into all the issue about soft opt-ins and opt-outs and all the business that you'll have heard of, which is complicated. It's very, very unclear what legal standards are required. The law's changing soon. It's not clear whether it's going to change in the UK or not. If the new law comes in after we left the EU, what then? People are very, very confused about the need for an opt-in, what the soft opt-in is, whether it still works, whether it's okay to have an opt-out, whether it's okay not to have consent at all for marketing. The law is unclear. Guidance from the regulators hasn't been great, I don't think. There's a lot of confusion around electronic marketing in particular and what standards you're expected to meet. Connected to that issue around cookies, what cookie notice you should say, is it enough to be able to say by continuing to use this site you are agreeing to blah, 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 or is a different standard needed? It's very, very unclear. And the whole area around electronic marketing and the use of cookies, I think, is a bit of a nightmare. Individuals' rights, as I've said, this is a kind of regulatory red line, and if you don't deal with subject access requests within the statutory timescale, which is a month, this is difficult. You can ask for an extension, but you're only supposed to do that in difficult cases, although it would seem that asking for an extension is becoming a kind of a normal thing to do, which is not right. But it is a regulatory red line. It's one that the ICO will get annoyed about if you don't give people their subject access requests. They're in the middle at the moment of an action against a police force who get tens of thousands of subject access requests a year, and they're failing to comply. So they will take action over these things. But subject access is the main right, but getting systems in place so that people throughout your organisation can recognise a request and know what to do is quite a challenge. The good old days when it would come in an envelope through the post saying this is a data protection at 1998 subject access request is gone. People will make subject access requests orally, they'll make them informally. They'll typically throw a subject access request in as part of some issue over a complaint, for example, whether they've had bad customer service. Oh, and by the way, I want a copy of all my data. We're seeing more and more of that, and getting all your staff, everybody with access to personal information, to recognise what a data protection issue is, be it a data breach or be it an access request, is quite a challenge. There are new rules in the GDPR. Well, the automated decision rules have been there for a while, but they're a bit different. And increasingly, we're seeing AI-enabled applications. We're seeing robotics. We're seeing things like mortgage applications being processed by systems rather than individuals looking at a file about somebody and deciding, well, you know, they're a decent risk or they're not, like it used to be. More and more of this has been automated. Robotics in the financial services in particular is becoming massive very, very quickly. So the things that go with that, the transparency, the right to have the decision looked at by a human being, are going to be challenging for organisations to deliver if they're doing high volumes of automated decisions and people are challenging them because they don't like the result. So that's a new area. It's one that we don't get asked about much, but I think it will become much more of an issue as we see more and more robotic AI-type decision-making processes going live. I think that's one of the sort of fears behind data protection law by the legislators, is that we'll all be the victims of nasty machines making horrible decisions about us, and we won't have any kind of protections, and that's one of the sort of bits of thinking behind data protection law. Another thing, which is I've kind of touched on already, but just getting the message across throughout your organisation to absolutely everybody, because nearly everybody in your organisation will come into contact with personal information to some extent. There may not be information professionals, may not be data protection people, but people in mail rooms, cleaners, everybody who deals with customers on the phone, people who deal with correspondence, they are all going to be becoming HR people. They'll all be coming into contact with personal information, therefore they're going to have, responsibilities to do certain things. The most obvious case is breach notification. That's a new duty. If you suffer a significant data breach, you may have to tell the regulator, you may have to tell the people concerned. The timelines for doing that are very, very tight. So if you've got people within your organisation who don't know what a data breach is and don't know how to escalate it, then you could be in trouble. And one mistake we see people making all the time is that they try and roll out staff training to all staff, and it's a kind of very lengthy law lesson on the GDPR and personal data means this and automated processing means that. It's not very effective, and we've done a lot of work trying to develop much more kind of role-specific, non-legalistic, practical guidance for people so they know what an information rights request is, they know what a data breach is and what to do, they know the basics around information security. So we've done quite a lot of work around that. And in terms of what we do at GT, it's the standard kinds of things, advisory, that's really my kind of role. Often people want a kind of sense check, and they look at the GDPR, they sometimes get legal advice in, and they get very worried and they get very confused, and to kind of sit with them and say, well, actually, look, these are your priority areas. These are the kinds of things you ought to be doing. This is probably not such a priority for you because of the kind of organisation you are. We do a lot of assurance and advisory work. We also do, audits of various sorts. And those are the kind of services we provide. And it does seem that, certainly there was a big, massive panic when the GDPR came in May last year. It's kind of died down a bit, but I think since the ICO started talking about its intention to issue very, very big fines, it's got a big boost in terms of people getting worried about this. And we've been doing quite a lot of presentations to boards and things like that to try and explain how your company can get a handle on these things. It's died down a bit, but it certainly remains a corporate issue and it's not going to go away. I think people will become more aware of this, and the ICO does annual tracking, and it seems that public awareness keeps going up. People will make more subject access requests. They will use personal information as a tool if they're in a dispute with you. And once, of course, you get a subject access request, then you get into issues of arguments over accuracy, content, this bit of the record's missing, why did you record this about me? You get into all that kind of stuff, so it's very much in your interest to have access or have people on your staff who understand these things. I think for a while, the demand for data protection officers and DP staff kind of exceeded demand a little bit, and quite a lot of people were hired who found it difficult, I think, to deal with all the aspects of the role. So that's it. We've got a few minutes, 5 minutes or so, for any questions you've got. But that was my little run through of what I think the main issues are and what we've been doing to try and help people